Okay, I imagine people are going to keep rolling in, but we'll just get started with some notes and announcements. Hi, everyone. Thank you for coming to our webinar today. My name is Taylor. I'm an admin coordinator at Community Legal Services. Just to let you know, the webinar today is being recorded. All attendees are muted and your cameras will be off for this presentation. There's no chat function enabled for you as attendees, though we can send things to you in the chat. I have these notes in the chat right now. The Q&A is open, however, so you can submit questions and we will answer them throughout the presentation. You can also upvote questions that are in the Q&A by clicking the thumbs up icon next to a question. If you see that someone else has asked a question that is the same that you wanted to ask or similar, you can upvote those and we'll try to get to those a little quicker. We will likely not answer all of the questions that we get today, but we will be sending out a follow-up email in the coming week with more answers to your questions. Closed captions are available during this webinar, so if you want to use closed captions, you want to look at the control panel of your Zoom window and click Show Captions. That should be an option somewhere along there, and then captions will show up live as the presenters are talking. Lastly, after the webinar, we will send out a follow-up email that will include the slides from this presentation, answers to the Q&A, a link to the recording of the webinar, and a transcript of the webinar itself as well. Okay, today we'll be hearing from three attorneys at Community Legal Services, Lauren Davis, Andrew Yang, and Mary Pat Pileggi. And with that, we're going to get right into the presentation, so I'll hand it over.
Thank you, Taylor. And hello, everyone. Thank you for joining us today. We have a lot to cover, so we're going to get right down to it. Taylor, if you could go to the next slide, please. Thanks. So a little overview of what we're going to cover today. First, we're going to talk about H.R. 1, which is the federal law that just passed in July that has created a lot of the changes to immigrant eligibility that we're going to be talking about today. We're going to do a review of some common terms referring to different immigration statuses that our clients tend to have quite often, and also that are quite relevant to understanding all of the changes that H.R. 1 made to immigrant access to public benefits. Then Lauren is going to lead us through a little bit of a deeper dive on the cuts to the SNAP program, and specifically the ways that immigrants are losing access to SNAP. Andrew is going to lead us through some of the changes to healthcare programs, including medical assistance, Pennie, and Medicare, and how the changes in H.R. 1 are reducing immigrant access to those healthcare programs. I'm going to cover some concerns around public benefit data sharing, and how that is creating fear within our immigrant communities when it comes to accessing public benefits. And we'll talk a little bit about ways to talk to immigrant families and immigrant clients about those privacy issues that people are really concerned about. We're going to do our best to save some time at the end for questions. Like Taylor said, there is a Q&A box, so you can put your questions in there along the way. If we do not get to your question today, we will do our best to get to it as soon as possible after today and get back to you with an answer. Next slide, please. All right, so starting with H.R. 1, you might have heard it referred to as OBBA or OBBBA, the One Big Beautiful Bill Act. It's this giant budget reconciliation bill that passed, signed into law on July 4th, 2025. It does a lot of terrible things to make access to public benefits harder for many, many people. It contains the largest cuts to Medicaid and SNAP ever. $900 billion in cuts to the Medicaid or medical assistance program, $300 billion in cuts to SNAP. That will have really dire consequences for many people across the state. 3 million Pennsylvanians rely on Medicaid, 2 million Pennsylvanians rely on SNAP. Today, we're going to talk specifically about the dire consequences for some immigrant groups because H.R. 1 made many cuts to immigrant eligibility specifically. Next slide. So some common terms, which is make sure everybody is on the same page when it comes to understanding just some basic terms about immigration statuses. You will hear us use all of these terms that I'm going to review with you now. You'll hear come up again when Lauren talks about SNAP cuts and when Andrew talks about the healthcare cuts. So we thought it would be a good idea just to do a brief overview of what some of these statuses are and what they mean. So starting with lawful permanent residents, or LPRs. These are folks who have been granted authorization to live and work in the U.S. on a permanent basis. People can be eligible for LPR status in a number of ways. Some people are eligible through a family relationship. Some people are eligible through their jobs. Some people have some other immigration status first that makes them eligible to adjust to lawful permanent residency. We have on this slide some examples of statuses that make people eligible to adjust their status to lawful permanent resident. So refugees, asylees, T visa holders who are victims of human trafficking, special immigrants from Iraq or Afghanistan, and special immigrant juveniles. All of those folks, once they get that status, they are then on a path to become a lawful permanent resident at some point in the future of their immigration case. There are also some statuses that people have that do not put them on a path to lawful permanent residency. I've listed just two of those examples of those here. And these two will be important to keep in mind as you listen to Lauren and Andrew's presentations later on. So people with withholding of removal do not have a pathway to lawful permanent residency. And then parolees. Parolees also do not have a pathway from parolee directly to lawful permanent residency. As proof of LPR status, people get a permanent resident card, which usually people refer to as a green card. Next slide. I've already mentioned the term refugees. Refugees have fled usually their home countries because they fear for their own life or safety, or they're subject to persecution that their government is either inflicting upon them or cannot or will not protect them from. They generally go through a whole lot of process, a whole lot of applications and reviews and interviews outside of the US before they get their refugee status. And so they have that refugee status before they even come to the US. As soon as they get here on day one, they have that refugee status in place already. Refugees are eligible for lawful permanent residency after they've been refugees for 1 year. Asylees, the test for asylum is the same as the test for refugee. So these are folks also who have left their country because of fear for their or their family's life or safety. The difference is that they don't arrive in the US with that refugee status already in place. They arrive in the US some other way, and then they apply once they get here for that refugee designation. Once they put that request in, once they put their application in for asylum, they are asylum applicants, and if their applications are approved, they will become asylees at that point. Asylees are also eligible for lawful permanent residency after they've had their asylum status for 1 year. Next slide. Cuban Haitian entrant. This is an important one, and hopefully this will be why it's so important will become clearer after you hear Andrew and Lauren's presentations. But in a nutshell, Cuban Haitian entrants have just about the same level of eligibility, the same access to public benefits as US citizens. That's true today, and it will remain true after HR 1. So it's really important to understand when you're working with a Cuban Haitian entrant, because that will make a big difference in their ability to access public benefits. Cuban Haitian entrant is a national of Cuba or Haiti who was either granted parole to enter the US, even if that parole period, that period of parole permission to enter the US has now expired, even if it expired years and years ago. Or even if it expired years and years ago and nothing else has happened in their immigration case since parole expired. Or even if their parole expired years and years ago and now they have some other immigration status, they are a Cuban Haitian entrant nevertheless. Or maybe they weren't paroled into the US, but they are here in the US and they have a pending asylum application. So they're not yet asylees, but they have submitted an asylum application that doesn't yet have a final decision. Or they're here in the US, but they are in removal proceedings. So the government is trying to deport them. They have a court date for a deportation proceeding in immigration court, but they do not yet have a final enforceable order of removal. So that's a lot of people from Cuba or Haiti who could potentially be a Cuban Haitian entrant. And a lot of these folks don't know that they are Cuban or Haitian entrants. I think especially Haitians don't know that they are Haitian entrants just because Haitians are more recent arrivals, usually, at least as far as I can tell, and at least as far as I can tell within our Philadelphia immigrant communities. You might have to do a little bit of work if you're working with somebody from Cuba or Haiti to figure out that they're a Cuban Haitian entrant, but it's worth it. It's definitely worth it to try to figure that out. And then our last term here is VAWA self-petitioner. VAWA is the Violence Against Women Act. And VAWA has been around for a while. What it does a bunch of stuff to protect people from domestic violence. One of the things it does is it says that if you are married to a US citizen or a lawful permanent resident, and you are eligible to become a lawful permanent resident yourself because of your spousal relationship with that US citizen or lawful permanent resident, and your spouse becomes abusive, you can separate from that abusive spouse and petition the government to apply for your green card, your lawful permanent residency on your own, separate and apart from your abusive family member. Once you get that permission back to do the green card application process on your own, you become a VAWA self-petitioner, and you can move along on your way through the process of getting your green card on your own. Next slide, please. All right, so as we move through the rest of this presentation, keep in mind that if you're working with somebody, that person's immigration status that matters is the person sitting across from you. Like, figure out who your client is, figure out who your patient is, figure out who you're trying to help get public benefits, and then figure out what that person's immigration status is, because that's the one that matters. The immigration status of that person's mom or dad, brother and sister, doesn't matter. It's the person who's trying to get public benefits whose immigration status you need to figure out. And with that, I will turn it over to Lauren.
Great, thanks, Mary Pat. Again, I'm Lauren Davis. I'm an attorney here at CLS in our Health and Independence Unit, and I'll be walking you all through the changes that are coming to the SNAP program following HR 1. Next slide, Taylor. And the next one also. Okay, so just a basic overview of the SNAP program before we get into the changes coming. SNAP goes to families or groups of people who live together and purchase and prepare their meals together. So it could be family members or people who are otherwise living together. Children under 22 must be part of their parents' SNAP household if they're living with their parents. The income limit for SNAP is 200% of the federal poverty line, or $64,300 for a family of 4 in 2025, for context. There is no asset limit for SNAP, and the SNAP grant can vary depending on the household size, income, and then other expenses can also be considered when considering the grant benefit amount, such as childcare and shelter costs. Next slide. Under the current rules, there are many humanitarian immigrants who can receive SNAP, including refugees and asylees, which we've already talked about, and Cuban Haitian entrants, along with a few other lesser known groups like special immigrant visa groups from Iraq or Afghanistan. And then there is some overlap among these humanitarian immigrants with qualified immigrants. So qualified immigrants include green card holders, parolees 1+ year, and VAWA petitioners. Qualified immigrants can get benefits after at least a 5-year waiting period, known as the 5-year bar, or by being exempt from that 5-year waiting period because of their humanitarian status, or other factors like being a child, receiving a disability benefit, being a green card holder with 40 countable quarters of work, which is roughly equivalent to 10 years, being in the military, being a veteran, being a spouse or child of a military service person. So really, there's a wide range of groups currently who can receive SNAP benefits, but a lot of that is changing very soon. And these groups may or may not have a waiting period depending on what category of immigration they are in. Next slide. So HR1 dramatically narrows this list that we talked about on the previous slide. And under the new rules, the only groups apart from US citizens who will be eligible will be green card holders, subject to the same 5-year bar rules that they are subject to now, Cuban or Haitian entrants, which Mary Pat just reviewed with us, or citizens of Micronesia, Palau, or the Marshall Islands, also known as the COFA nations. This is a group that we don't really see in Pennsylvania. So most likely when you're dealing with someone who will remain eligible for SNAP under HR1, they'll be in one of those first two groups. This means that many immigrants who have historically qualified will lose access to their food assistance. They'll have to balance this against other expenses that their household will have, such as, their housing costs, utilities, things like that, and food security will increase for their household. So this is a significant change that is coming to the country and to Pennsylvania and immigrants specifically. Next slide. So here we just have two tables to help us visualize how large of a cut HR1 makes to SNAP eligibility guidelines. So you can see on the left hand, we're going from all of these different groups in the green box to only the 3 groups on the right hand side, one of which we don't really see in Pennsylvania. So again, this is a significant change. Some of the most significant changes we've seen to immigrant eligibility for benefits since 1996. And it's a big change people need to be prepared for. Next slide. So here we have a table that dives a little bit deeper. So on the left-hand side, you'll see groups that will no longer be eligible for SNAP under HR1. The middle group, they will remain eligible for SNAP, but only if they're green card holders. So as an example, a group that this will be a big change for are refugees and asylees, who are humanitarian immigrants who currently could get SNAP like almost immediately. But under HR1, they will need a green card before they're eligible. That applies for the other groups in the middle column as well. Please note that VAWA petitioners are subject to a 5-year bar waiting period. So this will be a big change for these groups in the middle. On the right-hand side, it's just detailing that SNAP eligibility will remain for these groups here, and so does their 5-year bar. Again, the 5-year bar rules for each immigrant category is not changing at all. It will still apply. So LPRs, they'll remain eligible for SNAP. Same rules that apply for their group will continue to apply. Cuban Haitian entrants will continue to be eligible for SNAP, exempt from the 5-year bar. And then COFA migrants, which we don't really see, but nonetheless, they're covered by this change, will remain eligible SNAP, but subject to the 5-year bar. Next slide. So we're still receiving information about the timeline regarding SNAP benefits, but what we do know is that the new rules will apply to new SNAP applicants starting November 1st, 2025. We don't know when current recipients will be affected. There's still pending guidance from USDA. On September 4th, USDA issued limited guidance saying that more details would be coming on implementation for these changes for immigrants by the end of the month. So we will definitely be on the lookout for that, and we will be in touch when we have more information about that. Next slide. So while we're waiting for that guidance, what you and your clients or community can do right now, you can make sure that the county assistance office has a copy of their green card, especially if they got their green card after they started receiving benefits. Make sure that the CAO has that on file and that they're aware of your current immigration status. Watch for notices from the CAO and respond as quickly as possible. If you're uncertain about what it means, I know CLS will be available to talk about these issues and maybe other legal service providers as well. To that end, if you receive a cutoff notice, appeal immediately. Our motto at CLS is to appeal now and think later, because appeals are often the fastest way to fix mistakes and also to preserve your clients' or community members' rights. At CLS, we will be taking those cases, so we would take referrals for those cases, and I'm sure maybe other legal aid providers in the area will be doing the same. And then lastly, check if they qualify for exemptions from SNAP work requirements. Because remember, in addition to all of these changes coming for immigrant groups, your client or community member will still have to comply or be exempt from the SNAP work requirements. And we did a more in-depth presentation about SNAP work requirements last month. So you can refer back to that webinar for more information about SNAP work requirements. And then we'll also have resources directly to that webinar at the end of this presentation if you need to go back and take a look. Next slide. So while we're waiting for more guidance, again, for current recipients, we're not sure when this will come into effect. It could be before November 1st, or it could be after November 1st. You can check out CLS's resources online for more details here at this page. We will be keeping this page updated regularly. Thank you for your time. Turning it over to Andrew to discuss upcoming changes to Medicaid, Medicare, and the marketplace.
Thanks, Lauren. My name is Andrew Yang. I'm an attorney here at Community Legal Services. I'll be talking about HR 1 changes to immigrant access to these different healthcare programs. Just as a kind of brief review over all the things that I'll be talking about today. So Medicaid is also known as medical assistance, or MA. It's a health insurance program that's available to low-income people. It's administered by PA/DHS through the county assistance offices. I'm also going to be, very briefly talking about CHIP, which is a health insurance program available to kids through age 19, also administered by PA/DHS, that provides health insurance for families up to 200% of the federal poverty level. Pennie is Pennsylvania's health insurance marketplace, so I'll be calling it Pennie, or sometimes the marketplace, where people can purchase private health insurance plans. Most people are eligible for subsidies to help them afford these plans. Although you can also purchase full price plans on Pennie. And there's also Medicare, which is a health insurance program that's generally available to people 65 or older, or who have received Social Security disability benefits after the 2-year waiting period. And that's administered by the Social Security Administration. So next slide. First, I'll be talking about Medicaid, or MA, eligibility changes. Let's go to that next slide. So the current rules allow a wide variety of immigrants to have access to MA. MA is available to anyone who's lawfully present. Just as a reminder, As Lauren went over, lawfully present is a very broad term that includes nearly everyone who's in the US with permission. If you kind of imagine a Venn diagram of these statuses, lawfully present is kind of the one that contains most of these other ones. The second one is humanitarian immigrants. This includes refugees, asylees, Cuban and Haitian entrants, human trafficking victims, T visa holders, withholding of removal, special immigrants from Iraq or Afghanistan, and also these kind of special parolee groups that are noted here, Afghans and Ukrainians. Next slide, please. Medicaid is also available to certain qualified immigrants, which includes lawful permanent residents, VAWA petitioners, and parolees who've been present for over a year. It's available to either immigrants who have had qualified status for more than 5 years, that is, they've met the 5-year bar, or for some reason they're exempt from the 5-year bar. And just as a brief review, the 5-year bar is a federal requirement that prevents some lawfully present immigrants from accessing federally funded means-tested benefits for a period of 5 years. So even if somebody is a lawfully present person, is a lawful permanent resident, for instance, they may have to wait 5 years before they have access to certain public benefits. All right, if I could have the next slide. So some good news is that there will be no Medicaid or CHIP changes under HR 1 for kids, that is, individuals under 21 years old, and pregnant adults through 12 months postpartum. So this big green chart here is going to remain true for kids under 21, as well as pregnant adults. Next slide. Unfortunately, there will be Medicaid eligibility changes for non-pregnant adults starting in October of 2026. So that is the open enrollment period of next year. So as you can see, there's a variety of eligible immigration statuses under the current law in that green chart to the left. And in that red chart to the right, this is the eligible immigration statuses under HR 1 as of October of 26. And that is green card holders who've had their green card 5 or more years, or less than 5 years, and are exempt from the 5-year bar, Cuban Haitian entrants, and COFA migrants. So the immigration statuses that will have access to Medicaid will be severely restricted as of October of 26 to essentially U.S. citizens and those 3 immigration categories. Next slide, please. So here's another chart indicating that MA eligibility, and it's similar to that SNAP chart that Lauren showed us earlier. So MA eligibility will completely end with individuals who are either parolees or under a withholding of removal. It will end for refugees, asylees, T visa holders, special immigrants from Iraq and Afghanistan, and VAWA petitioners, unless they get their green cards. And it will only continue for lawful permanent residents, Cuban Haitian entrants, and COFA migrants. Cuban Haitian entrants and COFA migrants are exempt from that 5-year bar. All right, next slide, please. Next, I'm going to be talking about Pennie eligibility changes. So as I said earlier, Pennie is Pennsylvania's healthcare marketplace. The next slide. So the way that Pennie works is that it gives folks premium tax credits, which are abbreviated as PTCs. Basically, what this is a subsidized health insurance plan. So it's also called the ACA subsidy, Affordable Care Act subsidy. They're generally available to individuals who are ineligible for Medicaid, CHIP, and Medicare, are between 138% and 400% of the federal poverty level, and do not have access to an affordable employer plan. Although it's also available, they can also be available to individuals above 400% of the federal poverty level. They're also available to lawfully present immigrants below 138% of the federal poverty level who are ineligible for Medicaid due to their immigration status. Just for instance, lawful permanent residents that are limited by that 5-year bar. Currently, PTCs are available to citizens, U.S. nationals, and lawfully present immigrants. And as we indicated earlier, lawful presence is a very broad category that contains just about every non-US citizen who's in the US with permission, and includes a variety of these different statuses. So this is going to change for plans that are set to begin on or after January 1st of 2027. So for any plan that you purchase, any healthcare plan that you purchase from Pennie that's set to begin after January of 2027, that plan will be restricted in terms of whether you have access to this subsidized healthcare, these premium tax credits. I can get that next slide. For plans set to begin on or after January of 2027, instead of being available to those who are lawfully present, PTCs will be limited to green card holders, Cuban and Haitian entrants, and COFA migrants. So that should probably be sounding familiar to many of you by now. There's also going to be additional verification that the law requires. It specifically, HR 1 specifically specifies that it requires at least affirmation of eligible immigration status. There's also a rule that says that lawfully present immigrants ineligible for Medicaid with incomes under 100% federal poverty level will no longer be able to receive premium tax credits. Okay, so basically, premium tax credits are the way that these health insurance plans on Pennie are affordable for most people. For a wide range of immigrants, after January of 2027, they will no longer be eligible for premium tax credits, meaning that they will at best need to buy plans at full cost on the marketplace, which is frankly unaffordable for most people. Okay, so moving on to Medicare eligibility changes. Thanks, Taylor. So previously, lawfully present non-citizens could qualify for Medicare if they met certain other requirements of Medicare, age, disability, and work history requirements. On July 4th of 2025, immediately after HR 1 passed, all new Medicare applicants needed to meet new immigrant eligibility requirements. So you needed to be, again, a green card holder, a Cuban Haitian entrant, or a COFA migrant. HR 1 is requiring Social Security to review Medicare enrollees no later than a year from July 4th of 2025, so July 4th of 2026, and notify them that their Medicare will end on July 4th of 2027. And on July 4th of 2027, all current Medicare beneficiaries who do not meet the immigration status requirements will be terminated from Medicare. So if a Medicare applicant currently, or if a Medicare enrollee currently is not a green card holder, a Cuban Haitian entrant, or a COFA migrant, they will at some point receive some notice that their Medicare coverage will end. And the law requires that on January 4th, 2027, those Medicare beneficiaries will be terminated from Medicare. So there are a couple options for adults losing health care under HR 1 that I want to go over. First, there is state-funded Medicaid. State-funded Medicaid is the full package of Medicaid benefits that's available to certain categories of very low income and asset lawfully present adults. So there is an income and asset requirement, and there's also that lawful presence requirement. So as I said earlier, lawful presence is that wide category, and also certain categories of these eligible individuals. And those categories can include individuals that are older than 59, parents of kids under 21, folks who have a disability, folks who are caring for an unrelated child or disabled household member, and then some time-limited ones, drug and alcohol rehab, and domestic violence victims. So those individuals may be eligible for Medicaid under those state-funded categories. Lastly, I don't know if you could move to that next slide. There's also emergency Medicaid. So emergency medical assistance is available for folks if someone is ineligible for state-funded Medicaid. It's a good idea to consider whether they're eligible for emergency Medicaid. This is available to people who meet all the other Medicaid criteria except the immigration status criteria, and who also have an emergency medical condition. And all of the Medicaid benefits are available for the treatment of the emergency medical condition specifically. And with that, I'm going to turn it over to Mary Pat.
Thank you, Andrew. So as you all have heard from Andrew and Lauren, there are many changes happening now, some changes that are happening next year to reduce immigrant eligibility for public benefits, including SNAP, medical assistance, Medicare, and Pennie. But there are also lots of non-HR1 related changes to federal policy and practice that are creating fear in immigrant communities and are, as far as we can tell, leading a lot of people to choose to not apply for public benefits at all, even if they're still eligible for public benefits. So we wanted to spend a few minutes talking about the big thing that I think is driving a lot of that fear, and those are concerns around privacy protections. Next slide, please. So top line on this, there are two federal public benefit agencies in particular, so USDA and HHS. USDA is the United States Department of Agriculture, and HHS is the US Department of Health and Human Services, that have made recent efforts to collect large amounts of public benefit data from states and or have shared public benefit data with the Department of Homeland Security. And of course, the Department of Homeland Security includes immigration enforcement, ICE, the immigration officials charged with detaining and deporting immigrants. So these are very scary reports about these data collection efforts and data sharing with Department of Homeland Security. There have been attempts to stop these data collections and data shares. Those attempts are ongoing. Some of those efforts to stop the data collections and data shares have had some success. So we'll talk about what's going on there in a minute. And then after we kind of go through what this data collection and data sharing efforts have looked like, we'll talk a little bit about what we at CLS, what's some kind of top line messaging that we're using when we're talking with our immigrant clients about how to think about these data collection and data sharing efforts at the federal level, and what that means in terms of people's safety when applying for public benefits. Next slide, please. So a brief overview here about how information flows through public benefit systems within government agencies. It starts with an individual who's sitting down with that public benefits application form in their hand, and they're filling it out and putting a whole lot of information. These public benefit applications ask people for a whole lot of information. For SNAP and for Medicaid, those applications go to the county assistance offices, which are the local arms of the State Department of Human Services. And the county assistance offices can sift through all of the information that they've received in an application, figure out what's relevant to someone's eligibility for benefits, and then they put all that relevant information about someone's eligibility for the benefits they're applying for into their computer system. And that computer record then lives within the state's public benefit computer system. Some of that information, not all of it, but some of the information in the state's public benefit computer record has to be shared with the federal government, the federal agency that administers that public benefit program. Has to be shared because the law says it has to be shared. So that information goes directly to the federal agency that's administering that public benefit program. So the SNAP information that the county assistance office has in their public benefit record for somebody goes to USDA, the United States Department of Agriculture. That's the federal agency that administers SNAP. The Medicaid information that lives in the county assistance office's public benefit record goes to the United States Department of Health and Human Services, because that's the federal agency that administers Medicaid. You'll see down at the bottom of this little flow chart here that the Department of Health and Human Services doesn't just administer Medicaid, they also administer CHIP, TANF, the TANF Cash Assistance Program, and LIHEAP, which is the Low Income Home Energy Assistance Program, where people can get grants during the winter to help them pay their heating bills. Next, Taylor. There's also this one, while the county assistance office is kind of sifting through all that information and that somebody provides in their public benefit application, the county assistance office has to verify that the stuff in that application is true. And when they're doing that verification process, they are allowed under the law to communicate with other agencies to get that verification that they need, including verifying people's immigration status. So there is a communication that will happen between the county assistance office and the Department of Homeland Security when the county assistance office is trying to verify that somebody has an immigration status that makes them eligible for the public benefit they're receiving. Federal statute is quite clear that that communication between county assistance office and Department of Homeland Security nothing about that can be used for immigration enforcement purposes. Next slide, please. In addition to that federal law that says that communication between the CAO and Department of Homeland Security cannot be used for immigration enforcement purposes, there's a lot of other law out there that protects public benefit information from being shared for inappropriate purposes. I've listed just some of it here. You don't need to worry about understanding all the words on this page. I really just made this slide to give you a tiny little sampling of kind of the breadth of the law that exists out in the world that protects people's information when they apply for and receive public benefits. In a nutshell, the only lawful way that information that somebody provides on their public benefit application, the only lawful way that can be used is to figure out if somebody's eligible and then give them the benefits that they're eligible to receive. There are very, very few other permissible uses of somebody's information that they provide in a public benefits application under the law. Next slide. Right, big but here. The federal government has been threatening, and in some cases it's from the news reports, sounds like actually using people's public benefits data for reasons that might not be permissible under all those laws that we just looked at in the last slide. So we've seen demands from USDA starting back in May 2025. They sent a letter to states demanding a whole lot of data from states on all SNAP applicants and recipients going back to 2020. The response to that was a lawsuit filed by advocacy groups. USDA then withdrew their demand, but then they submitted what's called a SORN. So moving on to kind of column 2 in this chart, or column 3, that SORN from July 2025, the SORN is a system of records notice. This is something the federal government has to do when they are proposing a new kind of data collection and data, a new database of people's information. They have to propose it in a SORN and then solicit comment from the public. So USDA did that in July. They got a ton of comments in opposition to their proposed data collection. Despite all of those comments in opposition to that data collection, they proceeded to demand the same amount of data from states. There was another lawsuit filed by 22 states that Pennsylvania finally joined just a couple days ago. 3 days ago, Pennsylvania signed on to this lawsuit with those other 22 states, fighting against USDA's attempt to gather all of this data. There's a temporary restraining order that's keeping USDA from collecting this data for now. Hopefully that will be extended to Pennsylvania too. In addition to the USDA's attempts to collect SNAP data, there are also attempts over at the Health and Human Services to collect Medicaid data. Starting in June, Health and Human Services sent a letter to a select group of states demanding a lot of Medicaid data. I don't think any of those states responded. Pennsylvania was not one of those states. I don't think any of those states responded to those letters. Each one of those states ended up suing the Department of Health and Human Services because in July there were news reports that the Department of Health and Human Services handed over Medicaid data for every Medicaid recipient in the country to the Department of Homeland Security. So like I said, there is another lawsuit filed by 21 states against Health and Human Services in response to those news reports. Pennsylvania is not signed on to that lawsuit, and we encourage them to join. Next slide. All right, so this is very scary, as you can imagine, for immigrant families. So the next few slides just walks through a few main talking points that we are keeping in mind when we're talking with our clients about all of this scary stuff. So first thing to keep in mind, if you receive public benefits or if somebody in your family receives public benefits, a lot of the information that you put that is in your public benefit record may be available to the federal government, including your name and your address. If you are receiving public benefits now, withdrawing from that public benefit program now is not going to remove your information from those records that are already in the county assistance office's computer record, and therefore also available to the federal agency that administers that public benefit program, right? So if you are getting Medicaid for your child now, if your child's been getting Medicaid for the last year, disenrolling your child from Medicaid will not remove your child or your name and address from the Medicaid record that lives within the state's computer system and that is potentially available to the United States Department of Health and Human Services. So there probably is no reason to do that, right? There probably is no reason to disenroll in Medicaid or disenroll in SNAP because it will not help keep your information out of the hands of the federal government. Next slide. If the Department of Homeland Security already has your address through your immigration case, applying for public benefits probably will not put you at any additional risk, right? So if you, for example, have applied for asylum and your address is on that asylum application, the Department of Homeland Security already has your name and address. So putting your name and address on a public benefits application is not going to put you at any additional risk that the Department of Homeland Security will know your name and address because they already know it. So if you are in some kind of an immigration process, probably these privacy protection concerns probably are not something that you need to think about because the information you're trying to protect through your public benefit application process is information that the Department of Homeland Security already has. Next slide. When you are applying for public benefits for certain members of your household, you are not required to provide social security numbers or immigration status information of the household members who are not seeking benefits for themselves, and you should not provide that information about those household members. So for example, an undocumented mother who's applying for medical assistance for her children does not need to answer immigration status questions or social security number questions about herself. She only needs to answer those questions for her kids. So she needs to put her kids' social security number and answer the questions about her children's immigration status, but she does not have to give the county assistance office any information about her own social security number or her lack of a social security number or what her immigration status is or is not. She doesn't have to answer any of those questions. Next slide. Some people get worried about this. I just wanted to point out that the medical assistance and SNAP application itself says this, right? So it's right here. It's in small print, so it's hard, it's hard to see it sometimes, and it's easy to miss. But it's right here. So this is page 1 from the PA 600, which is the application form you can use to apply for SNAP and medical assistance. And I've circled here the part where it says that providing a social security number is optional for people not applying for benefits. So if you're not applying for benefits for yourself, you do not have to answer the social security number question. Next slide. And then this is the part of the PA 600 that asks you to list information about each person in the household. And you'll see there's a question, this first circle, red circle here, has the question, are you applying for yourself? And there's a yes or a no. If you check no, then the second circled piece of information here tells you that you don't have to answer any of the rest of the questions about yourself. And you'll see that those questions that you don't have to answer include questions about immigration status. So it's sometimes confusing. People don't always put all these pieces together on the PA 600, but it is right there. If you're not applying for yourself, you don't have to provide an SSN, and you don't have to answer any immigration status questions. Next slide, please. Last but not least, this is probably an obvious one, right? But we all know that public benefits programs can be very important, sometimes crucial for families who need them. So for each family, it's going to be different, but they will need to just sit down and think through and kind of weigh the risks and the benefits of applying for benefits or not applying for benefits, and make a decision that's best for their family. Next slide, please. All right, this last slide here is just some resources that you all can check out if you are interested in learning more about any of the topics that we talked about today. The top resource here is just about the SNAP changes. SNAP changes are happening, including work requirement changes are happening right now. And a lot of people are at risk of losing their SNAP. So check out our webpage on that. A lot of people are at risk of losing their SNAP, but also a lot of people are probably exempt from the work requirements and could save SNAP for themselves if they act now to show that they are exempt. So check out our webpage on that. And our webpage on SNAP changes includes a flyer about the immigrant changes. The State Department of Human Services has policies on everything we've talked about today. You can check them out yourselves. We have links here. And then the Protecting Immigrant Families Coalition is a wonderful group that puts out a lot of really wonderful resources for families, including on resources on the privacy concerns that we've talked about today, and also on public charge. We didn't get to public charge today, but I know people still have questions about public charge, and you can check out more information at the Protecting Immigrant Families Coalition website on that if you're interested. And I think that brings us to the end, and we do in fact have a few minutes for questions, which is great. So let's check it out.
All right, great. So we have this upvote system. Top question, can someone please explain the 5-year bar?
Yeah, that's a question with probably a long answer. When you get the slides, check out slide 10 for SNAP, and what's the slide on Medicaid? The slides 19 and 20 on Medicaid for more information about the 5-year bar. The federal law creates a 5-year waiting period that applies to many qualified immigrants. So qualified immigrants sometimes have to wait 5 years before they can get a federal benefit like Medicaid or SNAP. Lots of people are exempt. Kids are exempt from both the SNAP and the Medicaid 5-year bar. Refugees, asylees, Cuban, Haitian entrants are exempt from the 5-year bar, so they don't have to wait the 5 years. And there are other exemptions too, which you can check out in those slides that I just mentioned.
We also have a question here about whether Medicaid benefit packages for adults who remain eligible will be changing. For instance, will they have decreased dental benefits? I think that's probably related also to whether we had a few questions about whether emergency Medicaid itself will continue to be available. We want to talk briefly about how some of these funding changes may change things in the future.
Yeah, it is a very good question. And we are all really, really worried about how the cuts to the federal funding within the Medicaid program will affect everyone. And we don't know what kind of choices the state is going to make in order to make their Medicaid budget work with the loss of all those federal dollars. It's something that we're thinking a lot about at CLS. I know a lot of health advocates across the state are thinking about it. I know that Governor Shapiro and Pennsylvania DHS are probably thinking about it right now too. So I think stay tuned. Once we know more, I'm sure we'll be letting folks know.
So for households where an adult is no longer eligible for Medicaid, but a child is, how is the ineligible adult's income counted? It's my understanding how if the MA household size is reduced, can the kid lose benefits if the parent's income puts them over the income limit for the smaller household size? Well, the answer is yes, theoretically, right? The parent's income is counted as part of that household, even if the parent themselves is ineligible.
Yeah, I think that's right. So most kids are in a category of Medicaid that we call MAGI Medicaid. MAGI is modified adjusted gross income, and it has a tax sounding name because the rules are pulled out of tax rules. So a kid's Medicaid household is almost always exactly what their tax household is, which is almost always their parents and the siblings that they live with. So as long as they continue to live with those parents and those siblings, the income of all of those people is going to count. The household size is not going to change. It's just that the parent will no longer be able to get Medicaid for him or herself if their immigration status makes them eligible next year.
And this might be our last question, but we had a couple of questions here about kind of the risk of applying for public benefits. Specifically, this question is, if an undocumented mother received EMA at the time of childbirth and the child then received MA, is there an additional risk for the household to later apply for SNAP benefits? And there was a similar question, I think, that I saw, Lauren, you were typing, maybe you already answered it.
Yeah, the second part of
yeah, go for it.
the second part of the question was, and is there an effect if they're applying for cash assistance? So another public charge question.
Okay.
Yeah, so I mean, I think the risk here that you're asking about, but correct me if I'm wrong, is a risk around privacy and whether the Department of Homeland Security can get their hands on the information in that public benefit application. There's a lot about this that we do not know. We're really relying a lot on the news reports. For the SNAP data collection, it is on hold for now. Pennsylvania has not handed over any SNAP information to USDA. But unfortunately for the Medicaid piece, all we know is that the news reports say that Health and Human Services handed over everybody's Medicaid data. We don't know for sure that that's true or how, like the details about what Department of Homeland Security actually has. So unfortunately, we just have there are a lot of questions around this that we don't know the answers to.
And that takes us to the end of the hour. We will be sending out the slides and a follow-up email, but also I think we'll try to answer some of these questions that we didn't get to, and a recording and a transcript of the webinar. So thank you all for your time and attention.
Thank you.